I was walking down the street, feeling kindly, when the wind came out your butt and blew my wig off. Oh, it was a sight to see, my hair flying in the breeze, 'cause the wind came out your butt and blew my wig off. People started laughing, they couldn't believe their eyes as my wig flew through the sky. Oh, what a surprise. I tried to catch it, but it slipped right through my hands, 'cause the wind came out your butt and now it's somewhere in the land. Oh, wind came out your butt and blew my wig off. Baby, you drive like shit. Did you see that car that you almost hit? I'd rather take the bus instead. Riding with you, I'm gonna end up dead. Don't ask me if I need a lift. Baby, you drive like shit. She just ran through, always stop. I ain't trying to get stopped by the cops. Baby, why the hell did I let you drive? It's a miracle that you're still alive. Don't ask me if I need a lift. Baby, you drive like shit. Whoa, 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 whoa. Look out, my girl is driving. Watch out, my girl drives like shit. Whoa, 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 whoa. My girl is driving. Watch out, my girl drives like shit. Woman ain't no, heard you think you're tough. Gotta let you know, I will fuck you up. I whoop that ass, talking all that shit, spank that ass till you tap like a bitch. No, I ain't playing, I'm here to kick ass. Whoop that ass, it's time to punch face. I'm the one who brings you pain in the ring. I whoop that ass until the bell rings. Already know that I do not play. Throw a punch like I'm cutting down hay. I whoop that ass every single night. Spank that ass till they stop the fight. I'll tell you the story of a man, a radioactive tip in his hand grew 10 times its normal size to help him get his money on time. He knew if a bitch was telling a lie, which was 100% of the time. Superpowers to make a bitch listen, thinking her naked with sex-ray vision. Beat a police station in a single bound, slapping bitches down to the fucking ground. His name was famous across the land. They called him the pimp named Superhand. Oh shit, yeah, his pimp named Superhand. He had powers no other pimp had. Oh fuck yeah, pimp named Superhand. That motherfucker was super bad. Asking for dinner ain't asking for much. You had one job and still fucked it up. Sometimes you gotta learn respect. I use my pimp hand to correct. It's called a bitch slap. Slap. Come get get your face clapped.
Who taught you to hate the texture of your hair? Who taught you to hate the color of your skin to such extent that you bleach to get like the white man? Who taught you to hate the shape of your nose and the shape of your lips? Who taught you to hate yourself from the top of your head to the soles of your feet? Who taught you to hate your own kind? Who taught you to hate the race that you belong to? So much so that you don't want to be around each other. No, before you come asking Mr. Muhammad, does he teach hate? You should ask yourself, who taught you to hate being what God gave you?
St. Louis police declined to provide an interview for this story, saying they cannot comment on specific personnel matters, but writing that, quote, appropriate disciplinary action will be taken if an officer is found to have violated policies. Urayu.
I don't know what policy that is. I don't know how. I just don't understand how you can see the video and not come up with know what the fuck you can do right now. You just, we're still investigating. How long does it take to investigate seeing some shit? I understand, yeah, I get you. You want to get off of just more than just the video, just the body cam. You probably want to talk to both officers, maybe talk to the officers that showed up on scene afterwards. But you still have the video, right? You still have the video, and you saw what happened in the video. No matter what any of them say, that video don't fucking lie, and you can hear them talking in the video. So what the fuck are you waiting? What are you wasting time for? You telling me there's nothing you can do? Or we'll if something violated our policy, we'll do something about it. Okay.
One's mother lives in Puerto Rico. She cannot believe what our reports have been revealing, telling us in a text message it was a, quote, lack of humanity, saying more, quote, I hope the full weight of the law falls on these so-called police officers. The state has sought to discipline their peace officer licenses, and Fitch says a lawsuit is possible, but criminal charges, he says, are very unlikely.
They just... Hold on, y'all. Y'all saw that last part. Criminal charges are very unlikely. So look. Once again, when I tell y'all they do not have an obligation to save your life, they do not. And that's the number one thing that most people wrap in their heads. We were indoctrinated as kids growing up with cops and Live PD, MASH, and all this other shit. We're indoctrinated where people have this fond view of cops. They don't have to save your motherfucking life, nigga. No criminal charges are likely, very unlikely, y'all, for them walking away from a call that they got called on where a man shot in the head. Left them there to die. No charges. Even though they're operating underneath the guise of being law enforcement, and most people had the sentiment of thinking, the thought process, yeah, they got to save this man's life. We're going to try to, get their peace officer license taken from them. That's what we're going to try to do. And maybe they might get sued, but, we're not going to charge for anything. And I just don't get how people are okay with that type of shit, man. You know how much money they take every year from y'all? It's from all of us. To fund this shit, and you telling me, okay.
Are very unlikely.
They just didn't act at all, which is certainly shameful, but criminal, probably not.
It is the body camera video, which we should appreciate, Fitch says. The video that told the whole story. Video that's there to protect the officers and also the public.
A supervisor reviewing the body camera video was the one that discovered that it wasn't handled properly and did initiate an investigation. And that's the way it's supposed to work.
That video telling us what truly happened.
Let's cruise around and come back.
Capturing what otherwise was concealed, the inactions of two officers.
Now, regarding that missing gun, police tell us their investigation into the stolen firearm remains ongoing, and they are actively monitoring their database to see if it is being used in any crimes. To date, there have been no hits to that database. The police officers, we're told, have left the department not long after this incident last year. They have not responded to our inquiries to talk to them. Warren has already lost his Missouri peace officer's license. Frazier has a hearing regarding his license tomorrow morning. We will certainly keep tracking that. I'm Lauren.
Yeah, man, that's crazy, man. Look, man, one of them lost his license, man. That's so terrible. And another one, he's in hearings to lose his license. But, you know, ain't nobody being charged with nothing. We ain't hear about no lawsuit and shit. This is crazy, man. This is crazy. Jack said, join the panel. Yeah, you can actually hop up. I got one more for y'all, man. One more that's gonna piss you off a little bit. But actually, it's not even. It might not piss you off, but it'll show you the process of this thing called qualified immunity for these cops, because we definitely got to talk about that. But it's crazy, man. They one lost their license, and the other one is in the process of losing his, but no charges. It makes you wonder. When the officer said, at least the police department said, we're going to review this and see if there are any policy violations. Well, clearly not rendering aid to a civilian in public while you're on the job and on a call for that civilian is not against company policy as a police officer. Get that through your head. They didn't violate company policy by not rendering aid. But morally, they'll try to go after their badge. They'll try to go after their license so they can't be a cop. But you didn't fire them. Or did you fire him? Matter of fact, let me see. Did they fire him? Let me see if they fired him.
Other people were sick. Video obtained by First Alert 4 Investigate shows the moments two former St. Louis cops walked away from a man they'd found in Forest Park. He was shot in the head, but still alive. The officers never tried to help, call for backup, or make sure that other people were safe.
Wait, hold up, man. Yeah, see, they didn't say shit about being fired or not. And then on top of that, they damn sure don't know what a gun is.
To date, there have been no hits to that database. The police officers, we're told, have left the department not long after.
Didn't even get fired, y'all. Didn't even get fired. Didn't violate one policy. That should make you wonder if you in that St. Louis area about your police officers. That should make you wonder in that area. Didn't even get fired. Had the ability to leave the office after leaving a citizen for dead. It ain't coming back 10 minutes later. You know, come back 10 minutes later and then, you know, trying to act like it was your first time showing up on the job or some shit. Yeah, we just got here, man. Dipped out. We don't know what a gun is. We don't know when y'all got the gun. One of your fellow officers think y'all done took the gun and threw that shit in the woods somewhere. Y'all kept it for yourself. You was about to throw his body in the woods. And look, it's just crazy, man. It's just crazy how this shit goes down. But the next one we got, y'all, is for the Lackluster channel. And I'm going to drop the link real quick. So I know Ms. Jackson says she want to get in on this one. The next one is coming from Lackluster. Now, when a lot of these situations happen where officers put hands on, like the second video that we covered, there's a thing that pops up, especially if somebody wants to sue the officers. Qualified immunity pops up all the time. And that's a legal term that gives cops a level of protection from civil liability. Like, you fuck them up, like they fuck you up, punch you in your face, and, you know, beat you up real bad. You got medical bills and stuff. You can't personally go and sue them if they are deemed to have qualified immunity. So this protects a lot of cops, where it ends up being that the city just gets sued, not the officers. Because I believe, personally, if you do something wrong to me, you should be the one to pay for it. I don't think everybody else in this neighborhood should have to pay for what the fuck you did. I think you should have to pay for it. But they're not, we're going to put it on everybody else. And it's not coming from the cops, because it's coming from the taxpayers. Even though some of them pay taxes, it's coming from the wide majority of people that are not police officers. Well, they have proceedings for this, y'all, and they have to try to prove qualified immunity. We're going to see how this goes. And normally, most of the time, cops get qualified immunity. It's that thing that Trump said he wanted to get rid of. He said, we don't need cops to have qualified immunity. They automatically got ultimate immunity. Yeah, that dumb shit. This is how the proceedings go. And we're going to go through them. I sped it up a little bit because this one does drag a second, but we need to hear it, and it's important because a lot of people don't know what the hell's going on inside these courtrooms.
This case represents a prime example of why police officers should be provided qualified immunity.
So it's reasonable to lift him up and tackle him and then start punching him and all that, even if he was prone on the ground and you could have just handcuffed him.
Yes.
Welcome back to the Lackluster channel.
I don't know what we're talking about.
In May of 2009, during a police chase, Jordan Branscombe wrecked and surrendered, but would later sue the involved officers for excessive force. The officers motioned for summary judgment, but the district court denied qualified immunity, and the officer's appeal was heard by the Ninth Circuit.
My name is Noah Blackman. I represent.
All right, so now he sued him. Obviously, the dude did something wrong. He committed a crime, y'all. But the way that they took him in, and we're going to see how they took him in, he decided to sue him for excessive force, all right? Now, one judge said, yep, we can go ahead with that, no qualified immunity. The state, the city, the police officers, that department are trying to appeal that decision. So this is the hearing. Now, if it gets denied right here, they have no qualified immunity. Now, the first judge could have been like, yep, qualified immunity, and that would have been it. Well, the guy could have tried to appeal it again to another court. You can always appeal one time. And pretty much they're here for their appeal. They want this qualified immunity. It's already been denied one time. Let's see why it was denied. Let's hear the arguments. Let's see what the judges have to say. And also the attorney for the person that was wrong, that was violated, or the one that's filing the lawsuit will also speak to.
Present the appellants, in this case, the San Ramon related police officers and department. I would like to reserve 3 minutes of rebuttal.
That boy look like a
Very well, we're going to begin.
That boy look like a discount Tim Hasselbeck. Discount Tim Hasselbeck.
And for the record, we notified counsel we will be playing some video exhibits today. Both of these are from the dash cam of the car. So we'll begin with the real-time exhibit G.
Yeah, let's see what happened. Let's see what happened. All right. That boy out here driving crazy. He might swerve and be in that corner. Whoa, whoa. There's a lot of smoke, The vehicle didn't stop, though. All right. It look like we got somebody on the ground. Okay, we got a person on the ground. Y'all, hold up. Y'all see it, right? It was a person on the ground. So I'm guessing they were yelling commands for him to get on the ground. All right, y'all can see right here. You got somebody on the ground, all right? So they told him to get on the ground. Person's on the ground. What happens next? Oh, Lord, I saw that.
And then counsel, I'll now play it as the slow motion, and I'd like both of you to be.
If y'all paying attention, right? You had a guy on the ground. Remember, this is a lawsuit for excessive force. He's on the ground, face down, chest down, and a cop comes out of nowhere from the back, and it looks like he's mushing his face into the goddamn concrete. That's what it looked like. And then he ends up getting flipped, it seems. And remember, this guy, supposedly, he suffered a lot of injuries. I think he even had a punctured lung from this situation. He's the one suing. So it's starting to look like he might have a case, but, I'm quick to the gun because when I see bullshit, I just call it right there. But let's watch a little bit more.
Prepared to focus on when the officers are pulling, either he's getting up off the ground or the officers are pulling him up off the ground. The driver obeyed orders at gunpoint to get out of the van and drop to the ground, face down. After surrendering, an officer pushed Jordan's face into the ground. Immediately after, he pulled Jordan up and pushed him down again, jumping on him. The other officers then punched and tased Jordan for several minutes before being handcuffed. Jordan suffered multiple cuts and bruises, a punctured lung, and spent 3 days in the hospital.
Your Honor, this is not a typical use of force case, especially on this particular record. This case represents a prime example of why police officers should be provided qualified immunity from suit. In essence, they should be provided breathing room when they're dealing with a very high risk, high danger, rapidly evolving situation.
But let me start here. The district court essentially said that looking at this tape and taking all the evidence into account, she couldn't tell whether Mr. Branscombe resisted in general, as I understand it, or either at that point or at later points. And therefore, it was a jury question. Now, can we question that determination?
Yes, Your Honor. There's no evidence in this record set forth by Mr. Lagos or his client that he did not resist at the critical moment that was played by
there's the tape.
The court.
What do you think about the tape?
Right. Well, we have Mr. Branscome's testimony.
I'm asking a legal question. My understanding of the legal background is that you can't appeal a summary judgment denial. You can only appeal the denial of qualified immunity. So are we not bound by the judge's determination as to there being conflicting facts?
Well, I believe that the court did not do the full Graham analysis. We are bound by what the court said was this supposed factual issue, which was whether or not Officer Stevens pulled up Mr. Branscombe, which started the struggle, or
Okay,
Mr.
so you agree
Branscombe.
that we're bound by that. So your argument departs from that,
Correct.
from the assumption that he did do that. He did pull him up. Because you have to take the facts most favorable.
Okay, so let's assume that. I mean, this is de novo, but let's assume that. So one of our arguments is that in and of itself, that action by Officer Stevens in this heated, dangerous situation is not evidence of any excessive force. So even if that occurred, there's no case law that says the officer could not do that at that point in time. In fact, the cases say.
But why would they do that at that point in time if they were trying to, if all they were trying to do was to handcuff the guy and get him into control?
Well, the reason, and it's in the record, is, and this
they said they didn't do it. But if they did do it, what would be the justification for doing it?
Officer Stevens is reacting to Mr. Branscombe pulling his hand away during the time when Officer Stevens is trying to control his hands. Then something happens that Mr. Branscombe gets off the ground and moves over to the side. Mr. Branscombe doesn't remember the point in time.
I think you missed the point of Judge Berzon's question. Because the district court has found that there is conflicting evidence here, you're going to have to assume the defendant's version of the facts, or at least whatever facts the defendants think that they can prove. Whether they can or not, whether there's just tons of witnesses against it, at this stage, in order to prevail, you've got to assume that we think that there's a Fourth Amendment violation, and then tell us that your officers have qualified immunity. You're going to have to assume that Officer Stevens had him secure on the ground and decided to pull him up, and that action was not necessary in order to subdue him.
Well, let's assume
counterproductive to subduing him, actually.
Okay, so let's assume that's exactly why we have qualified immunity. I mean, here we are breaking down in milliseconds these brief actions by these officers in what even the district court admitted was the highest threat profile situation. So Officer Stevens is entitled to some breathing room for whatever tactic he believes at that point in time is necessary to control this gentleman.
But not if you could look at this thing and say he was pulling him up. The guy never resisted. Not only didn't resist then, because I think that's the way you read the district courts. And they punched him and they tased him.
Well, if your honors look at that video, what we do see right after that point in time is we see Mr. Branscombe move over towards the van, presumably at that point not in contact with an officer. Then we see Officer Stevens tackle him. So there's clear evidence that he lost control.
But the defense's argument here, I don't know whether it's a winning argument, okay? And I have my own views, but they're irrelevant here, is that if the officer has pulled him up, he's pulled him up at a time when that is exactly the wrong thing to do. He's got him on the ground. And if he's pulled him up, then Mr. Branscombe may simply be reacting to that. In other words, the officer may have pulled him up for the precise reason that it will free him to punch him, to get that attention grabber. And the other officers can tase him in order to punish him for what he's just done. So that's a theory of the case. I'm not sure you get qualified immunity for that.
Well, I'm gonna stop right there. I got Miss Jackson up in the building. What's going on, girl?
What's good, man? How's it going?
Man, living a dream, covering these motherfucking people. I would just go with people right now. Hey, what's your thoughts so far? Because like right now, pretty much they're doing it here, and we saw the video a couple times. They're going to consistently show it throughout this video. But what's your thoughts so far?
Well, I've been kind of had a lot going on and been running around kind of active, so I've been glimpsing in and out, jumping in and out. I just heard a little bit of the narrative storyline about the guy Jordan, and they arrested him. And it was accessible force use, right?
Yeah, here you go. Check this. Before you answer then, I'm going to play a little bit more because they're going through the proceedings pretty much right now. The judges are talking to the lawyer for the police department, police union lawyer, pretty much. And he's arguing on the side that they should get this qualified immunity, even in spite of what's going on. You're just going to see the banter back and forth a little bit between the judges. And eventually you'll get to hear from the lawyer of the actual guy that's filing this lawsuit. Because it's kind of funny. I'm gonna let you listen to it again, and you'll see the video on the side because they're gonna show it again.
I don't think that action by Officer Stevens, let's assume that occurred, is excessive force in and of itself. Okay.
But that's the way you briefed it, and the point that I think Judge Bybee is making, or in any event I'm making, is that's not the whole story. The question is that it was part of a larger that the judge. thing, and not just whether he pulled him up or not, but pulling him up was the first provocation. And there's certainly case law saying that when there's provocation, i.e. When the police do something that they don't need to do, and that has even some force, even if not a lot of force, then what happens afterwards has to be looked at in light of that provocation and not in isolation. I mean, your whole briefing was in isolation. And the question is, if we don't look at it in isolation, but look at what happened afterwards as part of the larger reaction, then why?
Well, that's what I think the district court failed to do here. I think the district court failed to look at the totality of the circumstances facing these officers.
I mean, on one level, they did a good job. I mean, on one level, they did, because they didn't shoot the guy as he was doing all these, terrible, dangerous things, and they.
No other civilians were injured, as far as I understand.
That's correct. I mean, under the Plumhoff case, Supreme Court case.
Look how even the judge is trying to give him a good job. Look. They didn't kill the guy, and nobody else got hurt outside of him. So, they did a good job.
Yeah, I caught that. She was like, they didn't shoot him, they didn't kill him, so they did a pretty good job. It wasn't too forceful, from what I'm perceiving.
I just don't understand that. That's very interesting coming from a judge, and then you hear the other judge, nobody was hurt, nobody else got hurt. I'm like, what? Okay, but let's see how it play out. This is crazy. It's crazy to me, but this is how this shit goes down in courts. This is a lot of shit, man. Look, if we got cops wearing body cams, we need to put cameras in every fucking courtroom. I don't care what the level of the trial is. Just don't show the jury. You can show the judge, show the lawyers, show the defendants, all that shit. We need cameras in all these courtrooms, because a lot of people don't even understand how court even goes down. They just see that shit on Law and Order and think that's how it's done. That ain't how that shit done, nigga. That's for TV.
And then how about his rights was not exercised? They were violated.
Mm-hmm. I keep talking for a second. I gotta turn something off. My internet about to start doing some funny shit. 1 second.
Okay. Well, I'm not quite sure of the narrative of this story. I'm really just jumping on for a minute. But we have a young man here whose rights were violated, and he was improperly arrested. As we know, our protocol and procedures, they have the rights to read you your legal rights once you're being arrested, what your charge is, and why you are being arrested. The only time that excessive force is necessary to be used is if the arrestee or the suspect is being violent towards the officer, and they have to physically defend themselves by, using excessive force to capture that person and take control of the narrative of the situation. So that's pretty much what
Don't say that, Jackson. Don't say that. Remember, the reason I say don't say that?
Well, no, you got to listen to the full cover lineup. I was talking while you stepped out.
I'm just talking about on the back end of the excessive force part. On the back end. Everything else I'm agreeing with. I wouldn't call it excessive force. Like, if they have to knock somebody out because they fighting them back, they wouldn't consider that excessive force. Excessive force only come in when it's wrong. Like, you exceeded the force you needed to get this done. That's why they call it excessive force. It would never be a good term for excessive force for them. It's always going to be negative.
Well, the correct definition of excessive force is, again, when someone is being violent or attacking the officer during an arrest, they call for backup, of course. And, they may have to physically restrain that person, meaning hold them down until they can get them handcuffed. Depending on the situation, possibly mace them. It just depends on the scenario. So that's just the overall picture I was painting.
I got you. Well, here, check it. Let's keep going. Fucking it's gonna get funny, and yell at me if you need me to stop at a point if you want to hit something on one of these, because it's gonna be a lot of shit said in this shit. Let's see how fast did I put this bitch on, but this seems like they talking slow. Here you go. We gonna do, matter of fact, at 125. I'm gonna put that bitch at 130. Yeah, 130. Let's see what we got.
Case, if this had continued, if he had been able to get his vehicle off of that area, officers would have been likely entitled under the Fourth Amendment and qualified immunity to shoot Mr. Branscombe.
Right, okay.
So now he gets out of the van.
But still, we have the situation that we have, which is the guy's on the ground, hands out, prone. And if you think that, and if you can look at that and it looks like somebody is pulling him up, or at least somebody could think that, then what? Not just the pulling up, is whether the pulling up is excessive force, but how does that feed into the rest of what happened?
Well, the rest of what happened, if indeed he had surrendered and submitted a total take me to jail position, why is there this 81-second struggle after that, where we've seen on the taser cameras, his arms are underneath his body?
That's all. That's not an argument for qualified immunity. That's an argument as to why you're going to win in front of a jury.
Well, I think it relates to the district court did not analyze the qualified immunity issues with, for example, the other 4 officers who the state of the record is they see.
Counsel is there's no Fourth Amendment violation. That's not qualified immunity. That's you're going to win that on the merits. Qualified immunity only comes in if we think there's a constitutional violation. So we have to assume that there's a constitutional violation for you even to make your qualified immunity argument, which is what gets you here today. Otherwise, you have to go before the jury and just say all of the officers testified that this is what happened. Mr. Branscombe doesn't remember. Here's the tape. Judge for yourselves. Vote for the officers.
The only reason that I guess
Think about that shit. They beat that man so bad in the head that he can't even remember what happened to him. The only way he'll be able to remember if he watched that video.
It sounds like another Rodney King situation.
He beat the shit out of him so bad. The officers remember everything. And they're saying one story, but their story is getting contradicted by the video. And the person that got victimized can't remember because y'all beat the shit out of him. Like, that's crazy. And we in court. This guy, I swear, some people that do certain jobs, I just don't understand how you do it. I don't know how you sleep at night doing that shit. Because you're sitting here arguing for these cops. This lawyer has seen it. This is the DA. I mean, not the DA, but the fucking police union's lawyer. You watch the video. You have freedom of information. You get discovery. You got to see the video. You probably saw the video before the goddamn people suing saw it. And you still in here arguing for this. I understand everybody got to get paid, but damn, we ain't gonna have some morals, man. Like, they beat that dude up, bro. They beat the shit out of him. You just, well, I'm gonna tell you why they don't need to get qualified immunity taken away from them. Like, what?
Just committed a whole nother crime. You know, you're arresting a man for committing a crime and you commit a crime. So is that not double standards?
Man, this shit don't even make no goddamn sense. It don't make no sense. You made me chase you, so now I gotta whoop your ass. That's what it seemed like. But either way.
As we're here, I think, is because I think we have a creative attorney, Mr. Lagos. He's based his whole case on what's seen in the video because his client basically doesn't remember how he got from the ground over towards the van. There's an 11-second gap here. So there's no evidence in the record.
I'm sorry. I gotta say that. He's basing it off of the video because his client doesn't know what happened. But in the video, he has an argument. What the fuck are you talking about? It wouldn't matter what his client had to say. We got the video.
Right.
You know, like people will lie all the time, but if we got a video that shows what happened, that's the end all be all. It don't matter what either motherfucker say. So it doesn't matter if his client can't remember. We have the video, dummy. And he said that like it's just gonna get dismissed because his client can't testify.
The receipts speak for itself.
Yeah, like what the fuck? I'm gonna let him say it one more time. That made no fucking sense, dude. That made no damn sense.
This is what happened. Mr. Branscombe doesn't remember. Here's the tape. Judge for yourselves. Vote for the officers.
The only reason that I guess we're here, I think, is because I think we have a creative attorney, Mr. Lagos. He's based his whole case on what's seen in the video because his client basically doesn't remember how he got from the ground over towards the van. There's an 11-second gap here. So there's no evidence in the record other than potentially Mr. Lagos' arguments about what he sees on the video because his client can't even bolster the fact that he was indeed picked up. The officer denies it. So I think the court did not.
We saw it, buddy.
And the officer denies it. Like, what?
So now you're just making your officer look like this is crazy to sit in here and argue this case in front of a judge. Like, they saw the video. They played it for you in the courtroom. The officer said he didn't pick him up. We clearly saw. Y'all had a conversation about the officer picking him up earlier, right when we started y'all whole conversation. This whole court proceeding.
It's a reverse psychology strategy, you know, that he's trying to use on them.
Like, don't believe your lying eyes, y'all. Don't believe your lying eyes. Believe what I'm telling you. I'm telling you the truth. Look at me. I'm the captain now. That video bullshit. Believe what I tell you. Like, that's crazy, bro. What are you like? This shit crazy.
Look at the totality of the circumstances that these officers faced in determining that one issue was that there was a factual issue as to whether the officer picked him up.
Do you think you could look at that tape and say, definitely they didn't pick him up? They didn't do that?
I believe so because all the evidence we submitted is that's not what happened. basically. That's not what Officer Stevens happened. That's not what I see in the video.
I understand, but I'm asking you about if you were looking at the video. Suppose Officer Stevens and everybody had said what they said, but you looked at the video and clearly they lifted him up after he was supine and after they were very close to putting the handcuffs up, and for no reason that you can perceive. Suppose that's what it showed. That would overcome whatever they were saying, right? I mean, that's essentially what the Supreme Court said in Scott versus Howard. I mean, you just look at the tape. All right. So if it were clear, it wouldn't matter what they said, right?
Well, I think the tape needs to be bolstered by admissible evidence other than just.
So you're saying even if it were clear, that wouldn't matter?
Well, I don't think it's clear.
I know, but
right.
So therefore, if it's not clear, you just said it's not clear. So if it's not clear, then do we decide who decides what it shows?
Well, it would go to the evidence in the case. Mr. Branscombe never testified that he was pulled up off the ground. So there's no evidence of that. So what we have undisputed on this record is our position. We have Officer Stevens saying that he's attempting to.
So you're saying we
corral
don't worry
this
about the ambiguous tape?
No, I'm saying that the tape should not be given undue weight here based upon the state of this record.
Counsel, let me ask you, I mean,
The video shouldn't carry more weight than your client's testimony. And because the other guy can't remember, we have to lean, ignore that video. We have to lean on what my client said to police officers. Even though the video shows that what they said was a bold-faced fucking lie. That's what he's in here arguing.
Right.
You got to be on some other type of time to be on some shit like, how much money they paying you, buddy? How much money are they paying you for this? It's just like when I see black folks out there cooning like a motherfucker. I'm like, man, what they giving you, buddy? What they giving you to come out here and say this crazy shit? How much money are they paying this lawyer? Like, ignore the video, listen to my client's testimony. His client can't testify, so automatically, we should get qualified immunity. That's his argument. That's pretty much his whole fucking argument.
Wow.
That's crazy.
Just to be clear, as I read the Ninth Circuit case law and the Supreme Court case law, we can't reweigh the facts to say whether summary judgment should have been granted at this point. As I understand the case, we have to assume the following. One, that Mr. Branscombe led the police on a very dangerous chase. And, behavior that is terrible, what he did, and could have hurt a lot of different people. When the officers came upon the scene, they were in a very tough situation. You don't know if more guys are in the van. The wheels are still spinning. He could have accomplices jump out. Very high tension situation. Granted, both of those. We have to assume, I think, based on what the district court did here, that at the time the officers came upon Mr. Branscombe, he was not resisting. Now, I understand your arguments to why the officers say he wasn't. I see the video, and we can all have our own opinions on that. But we have to assume for now that he wasn't resisting, and that despite him not resisting, force was applied to him. Am I wrong in my legal analysis that that's what we're stuck with at this stage?
Well, I think because of the backdrop of this, Your Honor, I think you're correct up to a point, which is these officers have a lawful right to use force. That's undisputed. And because of the severity of the crimes and the danger of the situation, they have the right to not just walk up to him and use kid gloves on Mr. Branscombe, not knowing if he's armed, not knowing his intents and motivations. So we cited the case law from the 11th Circuit and the 7th Circuit, the Johnson case and the other case, the Crenshaw case. Officers do not need to assume this gentleman is surrendering based upon all of his prior behavior. In fact, the reason this pursuit ended was he crashed his van. He did not pull over and suddenly lay on the ground and say, okay. That may be a different factual scenario. In this scenario, the situation that these officers faced, from their perspective, they're entitled to some breathing room on the decisions they're making, including whether or not Officer Stevens is pulling up Mr. Branscombe briefly, as the district court seemed to think occurred. So this is exactly why qualified immunity is provided to officers.
If he had his arms, what they claim was the resisting was that he moved his arms.
That's right. That's undisputed. Officer Stevens says that when he tried to get his arms from his head, start to pull back behind his back where you handcuff a suspect.
Who smushed this man's face into the ground? What would be your first reaction if somebody smushed your face in the ground?
And then I'm looking at the point the judge, the guy said, the judge said about they had a right to use forceful act. How do you figure? You charge him with eluding the police. He crashed his van, okay, and then when you all approached him, then you go ahead and arrest him. I still don't see how they're justified, or he's stating they had a right to use forceful act. That's just I'm a little lost there.
Yeah, and that's why I'm gonna play this shit. I'm gonna play this part again because the lawyer just tried to say, well, it was justified when he moved his hands. They were trying to get his hands and he moved his hands. Well, that's why I asked the question. If somebody smushes your face in the concrete, what would be your first reaction? What would be your first reaction, Ms. Jackson? If somebody was smushing your face in the ground, you on your stomach, face down, they smushing your face in the ground, what would be your first reaction?
Right, because naturally he was prepared. He knew he had it coming. You know, he running from the police. Once he wrecked his...
I'm asking, what would you do? What would be your first response?
Well, I'm just saying, everybody will have a natural instinct. You know what I'm saying? To defend yourself. But I'm saying mentally,
what would you do?
Right.
Saying, what would you do? Like, what would be your reaction? You already got to think about it. You got somebody on your back, obviously. You're probably not going to be able to get them motherfuckers to fuck off. But they smushing your face in the ground. What would you do? Because my first reaction,
you're going to have a natural instinct to defend yourself. That's just anybody. But what I'm saying is, I'm talking about, okay, from the start, from the basics of the scenario. Once he crashed his vehicle, he knew he had it coming. There's somebody been in and out of, the judicial system and law enforcement. It sound like he got a history, all his life. So he know what time it is. So once he crashed that vehicle and he knew he couldn't get nowhere, then he already prepared to lay it down. I'm quite sure. So once they approached him, either he resisted or surrendered. I did miss the video. I hadn't really looked at it to see the exact.
I'm about to show
you. See what I'm saying? But it sounds like once they approached him, they just naturally used physical force. They just went and beat the man down. They didn't even take the initiative to arrest him. That's what I'm gathering. From the testimonies.
Yeah. Well, here you go. From what the point I was trying to get at, and the reason I was asking you, what would be your natural reaction if you were getting your face smushed in the ground? The reason I was asking that because we're going to see what he did in the video, and I think most people would. I wasn't going for the term of defend yourself. He went to cover his face, to get his face off the concrete. That was probably the most natural reaction anybody would have. If you got weight on your back and somebody's pushing your face in the ground and they're about to scrub your shit in the ground, you're going to try to cover your fucking head from getting scraped the fuck up on the concrete. And the lawyer right now is trying to argue that he moved his hands. But what is the reason for him moving his hands? And they about to play it again. Here we go. Check it. Watch it real quick.
That he moved his arms?
What I meant.
That's right.
Yeah.
I was saying that's what I meant by you would naturally defend yourself. You would protect your head, put your hands over your body, cover your face or whatever the case may be, or even try to, move away or separate space. So that's what I meant by right. So that's what I meant by a physical reaction or natural reaction to defend yourself. That's what I was meaning by that. But what I'm trying to get to the key point is, you're saying they were smushing his face in. Is this after they arrested him? After they placed handcuffs on him? Or they just initially approach him and attack full force? And basically, he was assaulted. There was no arrest. That's what I'm gathering.
Yeah, I'm about to show it again so you'll see it. That's why I wanted to pause it, because when I heard the lawyer say that about he moved his hands, I'm like, okay, well, there's a reason why he moved his hands, and it wasn't to resist. Watch it. Watch the video.
Right, it's undisputed. Officer Stevens says that when he tried to get his arms from his head, start to pull it back.
Man jumped on his back and got his hands around his neck, pushing his head down. His hands are still flat right now, flat and straight on the concrete, flat and straight. But once more pressure gets applied to his head,
back behind his back where you handcuff,
he reaches one hand to his face. That's why he moved his fucking hands. The lawyer's trying to say that he's justifying that they had to use excessive force because he wouldn't give their hands, but why did he? Because his face was getting smushed on the fucking concrete.
Okay, so are they walking him? They're walking him to the police car at that point?
No, his car had just crashed. It just stalled out on the middle of the road, and they kept ordering him to get out of the vehicle, and get on the ground. He got out the vehicle and got on the ground. And then they're approaching him to arrest him, but this is what they did when they arrested him.
Right, because on that picture right there, it looks like they're walking. I don't see them on the ground. Let me see. The original picture I saw looked like they were walking. Okay.
Yeah, they're walking up to him. They're walking up to him.
And so he's on the ground. Okay, I see.
Yeah, that's him on the ground right there.
Arms from his head, start to pull it back.
Officer comes from behind, puts his head in the ground.
Behind his back where you
moves his hand. Now the officer's grabbing his hand.
Handcuff the suspect. He pulled one of his arms away. So at that point, Officer Stevens is trying to maintain control of him. And that's when we see Mr. Branscombe
Now they yank his ass up off the ground. He's bent back like a pretzel right now. They got him picked up.
Dive over towards the van, and Officer Stevens tackle him to the ground.
And he tackled him into this vehicle.
It sort of belies logic that officer.
So that's the whole video of the incident. Now he's once again going to go back into arguing why his officers were right to beat him the fuck up and puncture his lung.
Stevens is going to try to pull up Mr. Branscombe, off the ground for some reason when, a split second later, he's diving on top of him. The record is replete and undisputed that he was just trying to
if he wanted to get his arms around him, then he would do it that way.
But can we even dispute what the record says? I mean, aren't we locked? I mean, getting back to my question, aren't we locked into those four things I just discussed? We can't, if the district court says, I find that a jury could infer that the defendant, that the plaintiff in this case, Mr. Branscombe, did not resist. At this stage of the litigation, aren't we stuck with that?
Yes and no, because I don't believe the district court did the full Graham analysis. So I think the court was fixated on that one point, okay? But the Graham analysis is several different factors. I think if the court had run through those factors and the court's report, the court's order is really short on reasoning on that point. So, and I don't believe the court even looked at it from the perspective of officers.
I take it that if he didn't resist, which I guess would include moving his hand, then there was no reason to pull him off the ground and put his arms around him and tackle him.
No, I don't agree with that, Your Honor, because of this context. This is the highest threat profile of these officers. They don't
so your position is that even if he was prone on the ground and in fact not moving, they still could do that.
Yes, well, they can take every reasonable action they need to get this gentleman into custody.
So it's reasonable to lift him up and tackle him and then start punching him and all that, even if he was prone on the ground and you could have just handcuffed him.
Yes, because when we're breaking down that one little,
I don't think he probably did understand everything she just said to him, but I'm gonna play it one more time. And he said yes to this.
That even if he was prone on the ground and in fact not moving, they still could do that.
Yes, well, they can take.
So even if he gave up, the lawyer's trying to argue, even if he gave up and he was not resisting, they had the right to beat his ass.
Well, he's trying to, explain his reason or justify, here's to the point, case in point, So that's where it looked like where he's going with it.
And look, it's simple. Look, they got the right to beat his ass. They got the right to beat his ass, even if he gave up. Even if he gave up. Like, that's crazy. that's crazy, but this is the argument in court. Amazing.
Every reasonable action they need to get this gentleman into custody.
So it's reasonable to lift him up and tackle him and then start punching him and all that, even if he was prone on the ground and you could have just handcuffed him.
Yes, because when we're breaking down that one little critical moment, these officers are having to force to make these split-second decisions. So once Mr. Branscombe moves away, which we see in the video,
but
and we see the rest of the struggle.
That's the answer to the question of whether he resisted.
Well, but we see the resistance. We see him hiding his arms.
We don't know whether he's moving away because he's being tackled and lifted and tackled, or whether he's been moving away of his own accord. That's the question.
But Mr. Branscombe never provided any evidence to say that once he lay on the ground, he never resisted after that. He doesn't remember, so there's no evidence of that. So that's undisputed as far as I'm concerned.
And I think we're running out of time here, but counsel, I take it your point is that even in light of this type of chase, this type of danger, that even someone who is appearing to not resist, you read the 11th Circuit case law to permit at least some force to still be used.
Certainly, the higher the danger to the officers, the more latitude they're entitled to use some force to effect this arrest, which they had a lawful right to do. They had a lawful right to.
Now, hear what he's saying. Even if the person is giving up, you're trying to say, and a court already ruled on this before, which is crazy, the 11th Circuit. Even if the person's not resisting and they gave up, there's still some force that can be used against them. We had a court in America that ruled that even when the person gave up, take me to jail, they can still apply force to them.
And then the question.
Go ahead.
Well, and the question is, was he resisting? That's the route that they're trying to get to see if extra force was necessary. Was any force necessary? Was he resisting? Now, it sounds like this guy has a track record. He had been in the system, in and out. So, and the fact that he had a rap sheet and he was eluding from the police or running from them was the mentality that, or at least their making that the reason or excuse of why they attacked him, why they just pretty much assaulted this guy and ran up on him and beat him down like that, because we don't know if he's armed. We don't know if he has a record, when we know that, he's already in the system. He's already, got a rap sheet. So this is a hardcore criminal.
You know what I'm saying? Did they say he had a rap sheet?
The judge made that statement. You earlier. Did you miss that?
I had to miss it. I ain't hear him. I probably when I had to walk away for a second. Yeah, I missed it. I ain't hear him. But shit.
Right. Correct. So that's one of the lawyer's key points he's using as a justifiable cause to why they use excessive force. But the root to it is what the lady is trying to dig out is, was he resisting? So that's the case in point that the attorney needs to prove.
There you go. We're going to keep going. Because I heard him a few times try to say what it was, but I don't think anybody's buying it.
To put their hands on this gentleman.
Well, they certainly did that. That's true when they did. But the question is whether. Well, I think we understand your argument. Thank you very much.
Thank you, Counsel.
My name is Panos Lagos, and I do represent Jordan Branscombe. This case is about a citizen's clearly established right.
Defense lawyer, y'all. This is the guy representing the guy that got beat up.
To the Fourth Amendment to be free from unreasonable seizure. This court should sustain the trial court's decision with respect to denying the qualified immunity request made by the defendants.
If under the Supreme Court case law, if we looked at that tape and we said, she's just wrong. I mean, you can just see clearly that he was resisting. And I'm not saying I'm saying that, but if we could look at that tape and say that, then would we still be bound in terms of Scott versus Harrod and Plumhoff by her summary judgment determination? If the tape were clear.
If the tape were clear that it showed
that it didn't show what she said, that there was no way you could look at that tape and think that he didn't resist.
Right. Hypothetical, he had an axe and he starts swinging it at the police officers, and somehow the trial judge just missed that.
Yes, you could review that. Yes. And in answer to your earlier question of counsel posed by the panel that was not directly answered, the panel does have the authority to review a finding of the trial court on what the trial court views as a material fact in the case. The materiality of that fact can be reviewed.
But is there any issue of that in this case? I gather the issue is what happened, not whether there's a material.
Good question. The only fact that was found to be material, which is, how do we interpret this video? What did happen? And the judge basically said she couldn't tell, and it is in dispute, and that cannot be decided by her. And it is a material fact. I have to agree with the judge that now, interpreting this tape.
That her determination with regard to the material, the disputed material facts as to your client's resistance was both as to the initial instigation and what happened afterwards.
No, she did not say that because of this chase that was material to a determination of the propriety of the force.
I'm talking about whether he resisted. I mean, my understanding is that if the initial force, although relatively minor, i.e. picking him up and tackling him, was completely unjustified because he didn't resist at that point at all. But they did it. And if he then resists, let's say, was she then saying, well, he didn't resist after that either? Or was she saying that because the officers claimed that he was kicking and flailing and so on? And there was certainly a tussle going on, but it could have been in reaction or involuntary reaction to what was happening to him. So is she saying that, i.e. he never resisted? Or is she saying that any later resistance was essentially a reasonable response to the provocation, or it doesn't matter what she was saying?
She didn't say either way.
Well, I thought she said sort of generally he didn't resist.
No, as to what occurred after he was pulled off the ground, whether or not he was resisting during the wrestling that was going on, she didn't say anything. But I think what can be reasonably inferred is that, as I said in my brief, whether or not he was pulled up off this position, a tactically inappropriate move as admitted by the police chief, frames the use of force that then occurred. And or any resistance that later occurred. As you said, if he was provoked unnecessarily so that people could inflict the punishment they did, that does frame the force issues.
Not if he had punched them or something, but there's no allegation that he did that.
That my client did?
Yes.
No, there's none. There's no claim.
They're saying he was kicking and flailing, essentially.
That is said, but we don't see it, but that is what is said.
Counsel, going back to a point that opposing counsel was making, I think we all can agree that the events that led up to this were very dangerous, very scary. Your client then is on the ground. He picks up his head, and I believe he says, "I didn't do anything." Now, an officer, I think, could interpret that as he's not complying because he's get down, he's kind of rearing up. Then when they get on top of him, then we see him being, I think, pulled up and the whole taser and the whole thing happens. Why is counsel wrong that in a situation where someone has engaged in this type of conduct, that the officers can apply at least some level of force to this guy to make sure he's really compliant? Because he hasn't been compliant for that whole chase. I mean, for 20 minutes, they have sirens on. He wasn't stopping. The only reason why it stopped was because the van got caught up. Those 11th Circuit cases, I'd like to hear your response to those.
Let me answer your question first.
Sure.
What transpired before is everything that you've described, but he surrenders. And at that point, the job of the police is just to simply take him into custody. And I agree. There is some force that an officer is entitled to use to accomplish that task. And the question is, under Graham, was it necessary force and appropriate force under all the circumstances? So I don't disagree with force. Now, the question is...
But doesn't it also have to be the case, in light of what happened earlier, that they are entitled to be somewhat...
rougher with the guy.
Not rougher. What I meant to say was something a little different. That they are that a very small appearance of resistance could have been taken seriously in light of the fact that he was so out of control earlier, right?
It should be taken seriously, but the training that is supposed to kick in is to follow their training.
So if, for example, they really you thought that he was that he took his hand out from the when the officer tried to put his hand on him, he pulled his hand out and put it under his waist. That's what they claim. Right now, if that happened, quite aside from whether he got up on his knees, would that be a reason to pull him up and tackle him? Given what happened earlier,
would it be a reason? No, it'd be tactically very inappropriate. It would expose the officers to a very dangerous situation. The most opportune position for handcuffing is to be in the position that he was ordered to go to. That's
yes,
why he was.
But I'm positing that he, in a fairly small way, that in other circumstances maybe they couldn't react to, but that given the fact that he had shown himself to be quite out of control in terms of his concerns about danger, maybe they could react to it more than they could otherwise. So, in other words, the context has something to do with this.
Most definitely it does, and I want to get to the distinguishing of the defendant's cases. My answer to your question is it's very factually dependent on a given situation, just as Graham tells us. When he's in that position and he's been ordered to show his hands and he's complied, there are a couple of things that should be triggering here. He's complying, number one. He's helpless, number two.
Okay, but I don't know what the tape shows about this, and I'm going to see. But if we could say from the tape that they're right, when Stevens tried to grab his right arm, he pulled his arm out away from Stevens and he put it under his stomach, which could have suggested that he had something there. Let's suppose I suppose we thought the tape showed that. Now, first of all, did the judge rule on whether the tape showed that? Is that part of her determination there was no resistance?
No, she did not make that determination. She couldn't tell. That's what she
couldn't
said.
tell is what I meant. She that was part of her determination that you couldn't tell.
Yes.
So we would be bound by that.
Yes.
But if we thought it did show that, definitely.
Then could you employ Scott versus Harris to substitute your judgment? Yes, you could.
And if we did, then the lifting up and tackling him might have been okay.
It might have been, but
So you understand that her determination encompasses that as well.
I do. And
not just whether he got on his knees.
But I'm here to tell you, and I've been telling the world that since we have Scott versus Harris employing that reasoning, and given what this tape does show, it does show unnecessary and inappropriate force throughout the surrender. And when you employ the Graham factors, he can't come here and say there was a significant risk of harm to the officer or anyone else when my client surrendered. That is the critical point in time that my case starts. It started in San Leandro 23 miles earlier. Yes, that's what led up to it. But the job of the officers were very simple. And tactically, they were neither honest and didn't follow proper tactics. And they inflicted unnecessary and inappropriate force.
What's the record show, by the way, about the...
No, he's right. He's right. And I get what the judges are doing. They're trying to play devil's advocate. So when the police attorney came up, they were questioning him on his stuff, giving him pushback, and they're questioning him. It seems like somebody, not going to say who, second guy, old man, seems to be better at arguing his case because his case kind of stands. It's like, yeah, it began 22 minutes ago. Yeah, he did run from the motherfuckers. But when they got to him and he was done, he was on the ground, there was no reason to do what they did to him. There was no reason to do all that. He gave up. And she's trying to be devil's advocate, trying to say, well, you know, the first judge was like, well, he lifted his head. Could they perceive that as being something? Moving his arm, could they perceive that as something? Maybe he had something in the waistband. Even though they already saw the video. They already played the video. But they're being devil's advocates. So I get it. But this old man, I think he's going to win this one. What you got, Ms. Jackson?
Yeah, man, it's pretty evident and clear that he's, you know, surrendered. Never resisted. He ran from them, you know, eluding them. But once, you know, he wasn't able to escape and they came up on him, you know, he surrendered. I mean, hey, it was 4 or 5 officers against one guy. And once they, you know, approached him and see he had no weapon or anything, then there was no need for accessible force. So, yeah. And the lady did ask a question earlier. It kind of slipped my mind. I was trying to recall it. But it was like, what, you know, to keep her to come back to me in a little bit. But it was like, yeah, like, is she serious about that key point? No.
Yeah, see, that's what got me with a lot of them. I think they playing devil's advocate, which is interesting. I wouldn't be a judge like that. I just want to hear the case and look at the evidence and let me hear your arguments. I wouldn't try to play devil's advocate, but I guess that's to get some type of understanding. But yeah, let's keep playing it. It'll come back to you.
If anything, about the injuries to your client.
Oh, the injuries? A punctured lung, $40,000 of bills, a bruised up face, and a back and an eye issue. And photographs to go with it. Photographs that show his face that was not injured when he first exited the car.
How did he have a punctured lung?
Not clear. I mean, he was struck. You see him in a violent tussle? That's a good question. I don't know. It could have been a fist. Distinguishing the cases. I didn't even read them, but I read them for the last 4 weeks just to prepare for today because I didn't think they would ever find a case where a person had totally surrendered in plain view, no matter what that person did, that would justify pulling a person up and inflicting the punishment that I saw. And indeed, when I read the cases, they do distinguish. They have very grossly distinguishing facts. People hiding in between dumpsters, hiding in the woods, a person exiting a car. This is after they committed some serious felonies. Person exiting his vehicle after the stop, and the dog had already been released because it was a drug call. And so, unfortunately, when the gentleman getting out of the car claims he got on the ground, which is all contradicted, said the court, the dog had him for a second or two, 5 or 10 seconds before they pulled the dog off. Totally different, factually, from our case, total surrender case. And I have to come back to Graham. Graham was utilized as the basis for the defendant officers for the denial of their qualified immunity motion in Blankenhorn. Similar circumstances. And the court said, you don't have to go back further than Graham to know that you cannot inflict any unnecessary and inappropriate force on a subdued person. Now, what is subdued is a good question. We have many cases cited by the defendants where we have it established you can't inflict any force or use any force on a handcuffed person. But in Blankenhorn, they noted that the person who was on the ground was in the control of the officers. This officer had every ability to control the situation, and he chose not to. And he did so at the peril of his own officers, and for all the reasons we hear in their brief. He pulled him up off the ground. He denied doing that. So I'm here to ask the court under Scott versus Harris and Rule 57A and the prior authorities in this circuit that permit for that where video contradicts the version of the facts by another party. I heard Mr. Blaskin say that he denied that the officer pulled him up. He didn't think it happened. He's not entitled to that. I have a video that says otherwise, and it's an insult to all of us to pretend that didn't happen here. It did happen.
You're not asking us to credit summary judgment for you.
I am.
Is that in your brief?
Yes, it is.
Do we have authority to do that?
I sure do.
No, we don't.
I have given you the authority, and I can give you more. I've asked you under the Rule 56F. I've made a cross motion, and as I'm entitled to.
But we don't have authority over the summary judgment motion.
Yeah.
It's an interlocutory appeal.
I ask you to read the authorities. And I'll start with Keystone Land and Development Company of this circuit, 353 Fed 3rd, 1070 of 2003 case.
Is that a qualified immunity case?
No, but it's a decision of this circuit that granted the non-appealing party judgment under this rule and the authority set forth in 28 U.S.C. Section 2106.
Defeating request.
What's that?
Because if we have the authority to do that, then we have the authority to review the district court's determination that there was in fact a material.
You might not be happy with the result. We were called on to issue summary judgment in this case right now.
I hear you, but you do have the authority in 28 U.S.C. Section 2106, Scott versus Harris, And the authorities I cited in my brief, in the conclusion, starting with Morgan Guaranty Trust Company, again, the court in that case said it wasn't necessary for the non-appealing party to have judgment entered in their favor after cross motions of summary judgment, even though it was not an issue.
The only circumstances is when it's called inextricably intertwined, and this whole set of law says it isn't inextricably intertwined. The qualified immunity question is a separate question.
I understand the point.
All right, thank you.
Thank you.
Counsel said that.
Look, he trying to get up out of there. And you're like, look, man, it's clear and it's obvious. So look, we just trying to get their qualified immunity taken away. And think about it, y'all. This is all about getting the qualified immunity taken away. So then they can go on into court and know that they can sue the officers individually and the police department. That's all this is about right now. It's not even about whether they're wrong or not. It's about taking away the qualified immunity. All these different steps to get something simple done. We saw them cops beat that dude up.
That we did not cite one case, or we only cited a case or something to that effect about this last-minute surrender issue. Well, in fact, there's 3 cases that talk about even if a suspect appears to be potentially surrendering. There's been 3 cases, Johnson, Crenshaw, and the case that followed them, Holloway, that said even if a dog comes up and bit a suspect who supposedly had surrendered, one case, the dog bit the gentleman 31 times. That was not found to be a Fourth Amendment violation. And the Johnson case.
Coincidence, those cases are all about dogs. Dogs aren't people, and they don't know whether the guy's surrendering, and the dog has already been released by that point.
Well, that's an interesting question.
What?
That's an interesting question. I don't know, but I think obviously in this circuit, dogs are more severe force than an officer who might have, in a split moment, pulled up a suspect to try to gain control. The Johnson case specifically says, and I think it answers Judge Owen's question, that not all surrenders, however, are genuine. The police are entitled to err on the side of caution when faced with an uncertain or threatening situation. What we just did today, Your Honors, in this nice confines here, is analyze these split-second decisions of these officers faced with one of the most threatening situations and unpredictable situations that they could face. I don't believe, even if we assume that Mr. Branson came off the ground a little bit by Officer Stevens, that was a provocation.
In order for you to prevail on qualified immunity, I presume, but this is why it's a jury question, or on the Fourth Amendment issue, you would have to say, or in qualified immunity, that even though he wasn't resisting, they could have thought he was resisting.
Correct, because this is viewed not from Mr. Branscom's thought process, or I was giving up. It's viewed from the perspective of officers, and officers are supposed to get allowance for having to make these really difficult split-second decisions, not only with their mind, but with their bodies to react to these situations. And certainly everybody, I think, concedes this was of the utmost threat profile that officers could face.
Okay, thank you very much.
Thank you.
Thank you.
Thank you, counsel.
It's a difficult case, Branscom versus San Ramon Police.
Yeah, that dude, he been losing his hair lying for motherfucking people that are evil. Lying for people that's been wronging folks. That's why he ain't got no hair in his head. Let's see what the judgment is, because I think they actually gave a judgment.
Department is submitted, and we go to the last case of the day.
Jordan ultimately pleaded guilty to various charges related to the chase and spent almost 2 years in jail. However,
All right. Now, the guy that was driving, the one that got beat up, pled guilty, spent almost 2 years in jail.
Upon his release, he received $240,000 after settling for the injuries he suffered during his arrest. The department had decided to settle just before the trial began, as the circuit courts affirmed that the officers were not entitled to qualified immunity.
So they didn't win qualified immunity. Think about this, y'all. Went through this whole process, and I'm going to play it again. Went through this whole fucking process and tried their best to fight it. And when it was about to go to trial after they lost qualified immunity, it's like, nah, just give them $200,000 of the taxpayer money. Yeah, just write a check for that. Just write a check for that. We ain't trying to go to trial. Listen to him say it again.
$1,000 after settling for the injuries he suffered during his arrest. The department had decided to settle just before the trial began, as the circuit courts affirmed that the officers were not entitled to qualified immunity. Despite losing their qualified immunity, the taxpayers were still forced to pay for the officers' wrongdoings through indemnification, which allows a municipality to take responsibility for its employees' actions and pass the buck on to you. Let me know what you think.
So picture that. Picture that. They went through all this waste taxpayer money to try to argue against harming this dude to protect their officers. And then after they lost that ability to protect their officers and they were going to get sued, they said, fuck it. Look, we're going to do our officers a favor. We're not going to let y'all get sued. We're not going to let them come after you personally. We're just going to take the taxpayer dollars for y'all fucking this guy up, and we're just going to pay him, and we'll just let it go like that. That's what we're going to do. We already got him locked up. He's doing 2 years. So we'll just give them the taxpayer money. That is Please just give me your thoughts. That's so interesting. That's so interesting right there. I'm coming right back. Go ahead.
Man, outrageous, man. You know, and it's ridiculous. It's been going on forever. And it looks like a big repeat to me of Rodney King, you know, that he was on a simple stop, or even if you have a warrant for a person's arrest or a traffic stop, whatever the case may be, and the officers just violently attack this guy. It's caught on camera. We have the receipts. The public and society can see that this individual rights were violated. And why is there a trial? Why are we going to trial? What is the need to go through protocol and procedures of a justification or rationalizing the officer's actions? Plus, on top of that, someone else pays for it. You know, they were found unqualified immunity, and somebody else pays for the officer's taxpayers. We do pay for their actions in the city. I believe I heard a part of that as well. But that's a repeat, man, of Rodney King back in the 1990s in LA, you know, when I was living there at the time. And, you know, LA's a diehard blue state, California rather, diehard blue state, and they don't play. When they snapped and had the riot, they meant business. They gave them the business. So, you know, but what is the purpose of a trial when we have the receipts in the video to see that this individual's rights were violated? That's where we're at.
No, I agree with you. It's just amazing how some people are still sitting here, like, because we done covered a good little bit of videos tonight. Like, it went from we having a what was the first video I covered? Mistaken vehicle. Can't even get the vehicle right. Can't even get the vehicle right and put a citizen's life in danger. And then, you know, the taxpayers are going to pay for that because you pull the guns out on this dude, you blocked him off, put him in handcuffs. He was technically arrested. People need to understand when they put handcuffs on you, you are technically arrested in a lot of states. Now, some states, they'll say you're just detained, but technically handcuffs on you warrants an arrest. They can release you, but you were still arrested. In the next video, a guy just not even wanting to talk to him. After having a conversation with him, not even wanting to talk to him. And they tased him. Well, I don't think they tased him, but they threw this old man to the ground. Next video, cops see a person dying, just walking the fuck away from him. Into this final video of this man doing something wrong and running from him. But once he couldn't get away, like Ms. Jackson said, he couldn't get away no more. He knew he couldn't. He gave up. And you still beat the shit out of him. In all of these situations, the taxpayers are going to end up paying for that shit. That's going to be, you might need some new roads in your city. The school in that area might need some upgrades. The kids might need new football jerseys. Ain't no telling, man, we might need to get some of these teachers some raises. We can't do that now because the people that are taking your tax dollars are out here violating people. So now they got to spend your money to pay them because they don't want to deal with it themselves personally. I don't know how many people are going to be okay with that type of shit. Well, I know there's a lot of people that are okay with that. But it's like you said, when that Rodney King shit was happening back then, a lot of people didn't give a fuck because you saw who the people they were doing it to. And I tell you, when you don't speak up, when they doing it to other folks, what's going to happen when they do it to you? And that video just showed right there, they fucked that white dude up. They fucked that white dude up. He had to come back and sue him, even after being in jail. Think about it, get out of jail and get $200,000. Ain't that nice? Like, yeah, I was out here committing crimes. Yeah, they fucked me up, though. See, I'm getting paid. This shit crazy, man. They do it, man. Look, I just don't. People need to be a little bit more mindful when it comes to dealing with the police. But before I rant, because I don't want to, Ms. Jackson, give me your final thoughts on the show tonight.
All right, final thoughts for the night. I feel like this is where we're at in the moment. You know, we don't too tough have to worry about a lot more of these trials and stuff to be concerned about when we have these executive orders being passed in the White House, you know, from Donald Trump, of course, for police immunity, where there's no accountability being held for their actions, that they can commit a crime, violate your rights, the constitutional amendments, the law that they are supposed to protect and serve for, and pretty much they're justified, they're covered, are insured behind it through all these executive orders that Trump is passing right now as we speak. I didn't hear anything pertaining to administration leave without pay. No charges were being pressed. Anything of them paying a price as a result of their negative behavior and negligence being as a duty to law enforcement that they made a vow and a code to when they were sworn in as an officer. Hey, this is not a game. This is people livelihood, people lives, and this is a career that police officers choose to get involved in. And they get sworn in just like politicians get sworn in, and our vice presidents and presidents and so forth. And you make a duty, a vow to that order. So, California had Rodney King back. When I say they gave them the business, that riot was bad, man. I was there. What I experienced and seeing my own, that was a bad riot. They, like I said, California is a diehard blue state, and they don't tolerate, there's zero tolerance for discrimination, race, prejudice, racism, anything of that nature, So, but yeah, it was like history repeats itself. And final thoughts for the night, we got to fight harder. Kamala tried to encourage us. We're not going back, to the 1950s. People have sacrificed their lives. People have been unalived and put in prison, and families being destroyed and separated for our freedom, for our vote and our voice, which is our power. And after all of this, we're going to pay homage to our ancestors and our leaders before us to go back to the 1950s. It's unbelievable. We got to fight harder. We got to rise up. We got to educate. We got to inform. We have to encourage our young people, because it's their generation. It's very important, for the young people that change is detrimental at this point. And man, it's Project 2025 is serious. It's real. It's coming into effect. So, hey, we just got to keep doing what we do, man. Teaching, informing, is power and unity, and never give up. Know your rights, exercise your rights, and your voice is your power. Final thoughts for the night.
All right, now I ain't gonna hold you. Look, man, stop talking to these motherfuckers if you ain't gotta talk to them, man. Like, I'm being dead serious, man. Look, until we get to the point where we're gonna have more people calling out this nonsense and standing unified, like Ms. Jackson was saying, this shit's gonna persist. It's gonna persist, and we have somebody that is in office. Why'd I always do this right when I get to the end, man? I'm saying some profound, like, whatever that big word is, trying to say some shit, and this shit won't act funny. All right, look, man, I'm gonna try to slide this real quick.
We got froze up for a second. Yeah,
this shit was some bullshit. But look, man, we do got somebody in office that wants to give carte blanche immunity to officers. We need to say something about this shit. We need to call this out, man. Nobody should have to go through this. I don't even care if you committed a crime. The officer's job is to arrest you and let the judges and juries deal with that shit. And you serve your time if they find you guilty. They're not the judge, jury, and executioner out here on the street. And we as Americans need to stop being okay with this shit, because when it goes wrong, we're the ones who pay for it, because they've set up a system so fine and so good that they will never be truly held accountable. You saw 2 officers walk away from somebody that needed their life saved. They didn't even try. And they didn't fire them. They didn't charge them. The only thing they did was try to comfort their fucking license. Like we gotta be real about this shit, y'all. If they gonna sign up to do a job, like Ms. Jackson said, they sign up to do this job. You're not forced to do this job. You need to do it to the highest level. And if you fuck up in your position, you should be held to a higher standard than any of us, me, her, any other civilian out here. We didn't swear an oath to uphold the Constitution. You did. I know about it when I was in the service. I had to abide by that shit. And there's more restrictions on people in the military than it is for people that are police officers in this country, which is fucking amazing to me. But look, I hope y'all get on the gravy train, man. Look, don't feel no type of way if you got to call out bad behavior in police officers. You should not feel no type of way, and don't let nobody try to shame you. If they wrong, they wrong. Just like if you wrong, you wrong. When you right, you right. Hold that shit to the road. Everybody got to be accountable for their own actions. But look, man, it's been fun. It's been great. I appreciate everybody that tuned in tonight. If you was watching over on the network, watching over on Let's Talk, or watching over on Facebook, man, hit the follow, hit the like, hit the subscribe, share the videos, turn the notice on, all that in the bag of chips. And we'll be right back here again doing this next Thursday, but we also will be live tomorrow because it's Friday. And you know I like to have fun on Friday. But we don't get the fuck up out of here, and we'll catch y'all in the next one as always, man. Peace.
Don't tell me about me. Stop telling 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 me about me. I don't need you to tell me about me.